Good morning, I'm Tom Guerra from CBIA, and today's webinar is designed to give you a high-level overview on solid HR practices you can take to prevent headaches from non-compliance and other worksite-related issues. With us today are Lynn Atkinson, Assistant Counsel for CBIA's HR Services, somebody you've probably all spoken with, Ian Alsparaco, President of Baker Street Associates. Baker Street is CBIA's preferred background search vendor in our member discount program. They've been part of that program for the past 10 years, and in that time, they've performed thousands of background checks for Connecticut companies ranging from mom-and-pop gas stations to some of the state's largest employers. Over the past couple of years, Baker Street has expanded the services they offer and will now, in conjunction with CBIA's member discount program, be offering HR-related audit services, which you'll hear about more later on. Today's webinar will last about an hour, and in that time you'll see that there is really a multitude of potential HR pitfalls that most employers don't address until it's too late. And now, if you can advance the slide for me, we can cover the fact that of the thousands of calls that CBIA HR Services get each year, over 3/4 of them are from employers, member companies, who are in the midst of a developing HR problem. The most popular calls we see include problems related to personnel policies and record keeping, benefits and benefits administration, payroll administration, including wage and hour related issues, COBRA and HIPAA, and discipline or discharge incidents. And really, to avoid these issues, and this is the whole reason we put this webinar today, you really need to do a comprehensive assessment of your HR practices. We plan on covering this today. If you have questions during the course of the webinar, in that lower right-hand Q&A box, you'll see an open field where you can type those questions in, get those questions into me, hit send. I will then get them to either Al or Lynn during the presentation. So, enough of me blabbing. Without further ado, I'd like to turn it over to Al, who's going to give you an overview about key areas of focus and then take us through the details of what needs to be reviewed. Al?
Thank you, Tom. Good morning, everyone. So, as Tom mentioned, and from time to time, we in the course of our work, in addition to background screening, I do security consulting and investigations, and very often I come across many of these issues one of my client sites, either in connection with an investigation or some sort of complaint. So we'll be talking about areas such as hiring, employing, posters, and the termination process. So an employment application, although it's not required by law, it serves several valuable functions. So it's an official record of employment. It's your business record that you have to hold on to, that you've created. It asks the right questions and the details it's seeking, whereas a resume is kind of a sales tool for somebody to sell themselves to you. The employment application is something that you can create, and you can have employment at will statements, authorization to contact references, notice of termination for falsification. That's kind of key, because a lot of times, in the course of a background check, we may come up with something where a person's falsified information, and it's a much easier way to terminate or withdraw an offer based on a black and white, discrepancy. Exterior drug testing is regulated by the Connecticut General Statutes, Section 3151V. You're required to give written notification to the prospective employee at the time of the application that you intend to do a drug test, and then conduct the test according to statutory requirements, and provide written notice to the applicant of positive drug tests. Employment offer letter, Connecticut, again, general statute, this is by statute, requires employers to notify employees in writing at the time of hiring the rate of remuneration, the hours of employment, and the wage payment schedules. And that's a lot of folks don't think that you have to give it to somebody in writing. You just tell them, hey, we're going to offer you this job, X amount of dollars, and per week. But the statute requires you to actually have some documents that you provide to the employee. So an employment agreement, a lot of companies will use an employment agreement, to secure certain things. protecting their rights, non-compete, those kinds of things. These elements that are listed here are pretty important in terms of how that agreement is crafted to make sure that there's a length of time that the restriction operates, the geographical area covered, the fairness of protection according to the employer, the extent of the restraint on the employee's opportunity to pursue his or her occupation, and the extent of interference with the public's interest. So again, you can create something to protect yourself and your business interest, but it's got to be fair and it's got to be something that would be enforceable down the road. Confidentiality agreement. Connecticut's Uniform Trade Secrets Act protects certain trade secrets from disclosure. It derives economic value, number one, not being readily ascertainable by others who can obtain economic value from its disclosure, and two, is the subject of a reasonable effort to maintain its secrecy. Those are key elements of that confidentiality agreement. The I-9, employment eligibility. In my experience, as well as I'm sure that the attendees would agree, the government doesn't always do such a good job, whether it's state or local government or regulatory bodies, at educating you as to what you need to do so you're in compliance. They just kind of put out a notice, a bulletin, like when I-9 came out. They sent out a booklet, and I'm not really sure how they distributed it because, I as a company never got one, and I was a taxpayer. But over the course of time, you're required, obviously, as a result of that act, to establish the individual's eligibility to work in the United States and their identity. Another slide here, the immigration ICE goes out and does enforce that. But before state and federal forms, Connecticut employers are required to report new hires to the State Department of Labor within 20 days of the date of hire. As I mentioned here, last year, ICE went out and conducted audits, and 12 Connecticut employers were fined a total of $132,584.25 for not being in compliance with the I-9 requirements. And they actively do continually pursue this.
This is for customs, right?
Immigration and Customs Enforcement, ICE. Right. So it's, again, they're the ones that enforce or responsible for enforcing that requirement that you know who you're hiring in theory and that they're eligible to work in the United States. And it became more enhanced after 9/11. The law was in place for many years, but they're putting more teeth into it. They're using, some of you may be familiar with, the E-Verify program, which is an electronic verification of their status. And there are a lot more. Right now it's still voluntary except for federal contractors, and there's some federal programs that require an employer to use I-9.
Right. I also would remind our attendees that feel free throughout the course of the webinar to type in your questions in that Q&A block below, and we will we'll get them to Al and to Lynn just to make the program as interactive as possible.
Okay. Personnel files. Okay, so again, Connecticut General Statute 31-121A defines what constitutes a personnel file. And what should be in that file, what can be in that file. And then under another statute, 31-128B, G, and H, there are components there that the employee has a right to inspect their personnel file. And again, some folks that I've come across had no idea that the employee can ask to see a copy of their personnel file. Meal breaks, Connecticut General Statute again, 31-51II requires, with limited exceptions, that employees who work 7.5 or more consecutive hours be given at least 30 consecutive minutes for a meal. Job description here, the note really is that, as you see, several state federal laws, including Americans with Disabilities Act, and the Connecticut Workers' Compensation and Disability and Discrimination laws, they affect job descriptions. You have to be careful when crafting a job description to ensure that you're not violating any of those statutes by what may be contained in that job description in terms of what you're requiring them to do. Sexual harassment. Employers may protect themselves against sexual harassment claims if, at a minimum, they do the following. It's really important, and I'll give you a quick example while I'm doing this here. To develop a strong, effective sexual harassment policy, which includes a definition of what constitutes sexual harassment, examples of the type of prohibited behavior, a choice of individuals to complain to about sexual harassment, a qualified pledge of confidentiality, and promise of no retaliation. And it's important to communicate the policy to all employees, and then, of course, to vigorously and fairly enforce the policy. An investigation I had a few years back, I had to go down to Florida to investigate a former employee's complaint of sexual harassment. The woman had sent a letter into the president of the company saying, I was in a hostile work environment, and what she described was she worked with another employee, and the other employee described to her the situation that happened when he was 5 years old, and he was, sexually assaulted by his uncle. And she felt that was a hostile work environment. She didn't want to hear that story. So I went to investigate, and I kind of blew a can of worms open. As soon as I walked into the office, the assistant manager sitting at a desk, and a staff associate comes up behind her and kisses her on the neck while he's asking for a change in his schedule for that week. And she was married, he was not. So I knew I was in a hotbed. And it turned out that, I came back to the stories, the things that I learned during this investigation. The outside counsel basically was red-faced most of the time that I was kind of giving her a report as to what had happened and what was going on in this location. So it's very important that any of that stuff is paid attention to. I'm sure that we wouldn't tolerate it, but, again, if it goes unseen, that's why it has to be communicated as a policy to all employees, because someone else may see it, and you want them to report it to you. You don't want to find out about it, the hard way, where someone's been affected by it. So if somebody sees something that they don't feel is right, even if it's not affecting them directly, making sure that they bring that to your attention is important so you can get out ahead of it.
Right. Got a couple questions here from our attendees, and I don't know if this is Al or Lynn who wants to take this, but the first question is, can an ex-employee demand a copy of their personnel file after they have left the company?
Yes, they can. They can demand it up to 2 times a year once they're an ex-employee, and we generally recommend that you have them put that request in writing.
Great. The next question is, are job descriptions required by law to provide to all employees?
Tom?
Yes?
Yes. No, not by law. I think Al already mentioned the Americans with Disabilities Act. Under that, it's a good idea, certain parameters, but they're not actually required by law.
Great. Thanks a lot, Lynn. All right, Al, we're ready to roll.
Okay. So disciplinary action forms. So again, these are not required, but having written documentation of a disciplinary action and a warning can be very useful. As an example, Connecticut General Statute 31-236A-2B renders employees dismissed for willful misconduct ineligible for unemployment compensation benefits. And I'd experienced this many years ago. We had an employee had an issue. We documented it and followed our own internal process. But it became very valuable. So I understood from talking to folks that it was pretty difficult for an employer to win an action in terms of unemployment. But we were successful, and I think it really had to do with the documentation, the fact that they were able to present, counsel a person, who gave them opportunities to correct themselves, and they just continued, the same behavior. And if anyone's attended, but they're pretty liberal. I mean, I had to show up in person, and the ex-employee could participate by phone. They didn't have to show up even, at the hearing. So,
interesting.
Time records, non-exempt. Okay, again, statute 3166 requires employers to keep an accurate record of hours worked by and the wages paid by the employer to each employee. And many of you may know this, but it's something that you need to be aware of, and I'm sure that none of us here on the call were not paying employees, but the Department of Labor takes that pretty seriously. If you don't pay an employee, they've actually criminally prosecuted people for failure to pay wages to an employee, and those people go to jail. So it's anything to do with timekeeping. I'm in the workforce, in management. I mean, over 40 years, and that was the first thing I learned: never mess with somebody's pay. Make sure that you handle problems when they crop up. If you made a mistake, correct it right away, because that's the quickest thing that will get you into trouble. Because an employee's going to complain. You got to pick up a phone call to the Department of Labor. and say, hey, I'm not being treated fairly, I get paid for the hours that I worked, or I'm working overtime, I'm not getting paid for my overtime. All those things are, they roll off people's, tongues in an after-hours situation. Oh, I call state labor department, So it's something to just beware of, be cautious with that. Employee evaluation form, again, not required, but if you have a properly completed performance evaluation, it can provide a number of benefits, cost-effective way to increase the employee motivation by providing positive feedback and accurate performance expectations, so everybody knows where they're at on the same page. Performance evaluations can provide accurate documentation for personnel actions and help avoid costly litigation. Again, you're making it clear what you expect from the person and telling them during the evaluation whether or not they're actually delivering to your expectations. Succession plans to be developed and influenced by strong performance management systems.
Again, employee evaluation not required, but a real good idea to have.
I mean, I think, from our experience, it's a great tool in our environment here. And of course, this wouldn't work necessarily for every organization, but we have our employees, with a guideline document, write their own evaluation so that they can, tell us where they think they're at, and then when we sit down with them, we either agree or disagree, or we tweak it, together as a partnership. And I think that's a pretty effective way of doing it. If the environment is, something that you can do that in, I think it's a great way to do it. Payroll deduction authorization forms. Again, Connecticut General Statute 3171E provides that no employer may withhold or divert any portion of an employee's wages unless, one, the employer is required or empowered to do so by state or federal law. Taxes. The employer has written authorization from the employer for deductions on a form approved by the commissioner, or the deductions are authorized by the employee in writing for medical, surgical, or hospital care or service without financial benefit to the employer and recorded in the employer's wage record book.
All right, in terms of COBRA is the Consolidated Omnibus Reconciliation Act, and it was passed 20-something years ago during the Reagan era, and it requires employers with 20 or more employees to notify their employees and the covered dependents that continued medical insurance coverage is available if they experience a qualifying event such as a termination or other qualifying events, divorce, death of spouse, and several others. Federal COBRA makes this coverage available for 18 months. However, Connecticut has their own state continuation requirements, and they originally mirrored that 18 months that the federal COBRA requirements stipulated. But Connecticut has one big difference. Connecticut state continuation requirements apply to all employer-sponsored health plans sold in Connecticut regardless of the size of group. And for the past 8 years, CBIA has been providing free COBRA administration for our insured members, as many of you may know. There was one major change that happened 2 years ago. May 5th, 2010, Public Act 1013 expanded the maximum continuation period to 30 months. So what that means is employees who lose coverage can now elect COBRA continuation coverage through state continuation for up to 30 months in the event of a layoff, a reduction in hours, a leave of absence, or a termination of employment. Again, this is a big change. It had previously been 18 months. In terms of the notices required for both state or federal COBRA, there are two. There's the initial notification of COBRA rights. The initial notification happens after somebody, or should happen after somebody comes on the health plan. Again, it makes them aware of the fact that there's a continuation option for them. After they've experienced a qualifying event, they should receive a second notification. Again, this happens after the qualifying event occurs. It says to them, now that you've experienced this qualifying event, you have the ability to continue your insurance through COBRA or state continuation. Again, for those insured through CBIA, we do this as a free service as part of the COBRA continuation program, and we're currently doing this for close to 4,000 companies. So if you're insured through CBIA, you don't currently have that go to our website. There's a service agreement. Fill that out. We'll start doing that for you. There's absolutely no charge for you as an employer, and it's really a very, very smart preventative measure you can take. Next slide, please, Al. Al referred to payroll requirements. Another relatively new requirement for Connecticut employers is Connecticut's Section 125 premium-only plan requirement. This goes back to 2007, and I think it was October 2007, Connecticut passed PA 07-185, which impacts all employers that provide health insurance coverage to their employees in Connecticut. Premium contributions through a payroll deduction. The employers must now be given the option to have these deductions taken out on a pre-tax basis. So what you need is a simple Section 125 premium-only plan document and a salary redirection agreement. The premium-only plan document is a boilerplate document that says the employer has the ability to take these contributions out on a pre-tax basis. The salary redirection agreement is a form that the employee signs saying either, yes, I want these health insurance deductions taken out on a pre-tax basis, or for some reason, no, I don't want those taken out on a pre-tax basis. Again, for those insured through CBIA, we make these documents available to our insured members at no charge. So again, look into, if you currently don't have that, look into that, and we will provide that document for you. It's a comprehensive premium-only plan document and the salary redirection agreement. So hope that was helpful. I'm going to now turn it back over to Al, who is going to talk a little bit about HIPAA. And again, continue to get us the questions, and I will get them to our speakers.
Okay. So I'm sure that all of us are familiar with HIPAA to some degree. Every time you visit a medical service provider or a pharmacy, you're asked to sign a form or a blanket form. But there are also obligations, obviously, as the employer. So many employers contract with or do business with HIPAA-covered healthcare providers, health plans, or healthcare clearinghouses, considered covered entities. And if an employer has access to, creates, or receives protected health information while performing services on behalf of a covered entity, it is considered to be a business associate under HIPAA. So basically, you now are in possession of that information, so you have to take the same kind of measures to protect that information. So identify how much protected health information is used and disclosed within the company. Execute contracts providing for compliance with the privacy rule with all third-party claims processors, insurance carriers, HMO, and others handling PHI. Appoint a HIPAA privacy officer. Create policies determining how PHI information will be handled, including use of authorizations, administrative, technical, physical safeguards, training, that means storage, where is it being stored, what computer, if hard copies, where they're being kept, how they're being secured. Maintain individually identifiable employee medical information as separate log files. Again, separate from the personnel file. Shouldn't be in the same file folder.
I've got a couple questions here. I'm going to take the first one, and it has to do with COBRA. Did I understand correctly? Again, this was sent in the chat section. Please send them in the Q&A section because not all of us can see the questions. But the question had to do with the initial COBRA notification is due upon initial coverage. That is correct. When anybody becomes covered under a group health plan, the employer is responsible for providing that coverage. And let's see here. There is actually another question having to do, this is probably for Lynn, is there an employee evaluation form developed by CBIA available to its members?
Yes, we have several evaluation forms that we can make available to a member. Basically, you should give one of us on the HR hotline a call, and we can email a copy of that over to whatever would be most appropriate for your company.
Great. Okay, Al, I think we're ready to proceed.
Okay. So Health and Safety Committee. Connecticut requires employers who have 25 or more employees at any single work site in the state, as well as employers who have 24 or less employees, whose rate of work-related injury and illness exceeds the average incidence rate to establish and administer a safety and health committee for each applicable worksite. So again, you have to be aware of this yourself, and the 25 or more is, fairly cut and dry, but if you have 24 or less, and you have to then be able to monitor the, your incident rate against, the average incident rate. And I'm sure that the CBIA can point you in a direction of where to get those figures, but it's important that you have that knowledge and awareness. And Connecticut has also established rules regarding committee membership, frequency of meetings, and record keeping. And that, again, if you have to create this safety committee, you have to know the guidelines and how you have to maintain it. And it's very important.
I have another question for, I think this might go to Lynn. If an employee is a salaried employee and they work less than the required 40 hours in a week and does not have sick time or vacation time to use, can this employee have their pay for that week reduced, or are we required to pay the salary amount?
Generally, if the employee is taking the time off for sick or personal reason and they're out a full day, you can dock them for the full day. If they work any part of a day, they must be paid for the full day, whether they have paid time available or not.
Great questions, people. And keep them coming, and we'll keep moving through this.
All right, so OSHA 300 illness/injury log. OSHA requires the log should show the following: when the occupational injury or illness occurred, who was injured, what the injured ill person's regular job was at the time of the injury or illness exposure, the department in which the person was employed, the kind of injury or illness, how much time was lost, and whether the case resulted in a fatality.
I had another question going back to the safety committee, and that was, where can I find the rules for the safety committee?
You can access those on the State Workers' Comp Commission regulations and some of the Workers' Comp Commission, so they have them online. And our website is www.cba.com in our safety and health section. We have them there.
Great. Excellent.
Okay. So OSHA 101 form for workers' comp, first report of injury. All employers regularly keeping OSHA records must complete a supplementary record for each entry in the OSHA 200 log. Either the OSHA 101 or any other form which contains the same information may be used. But again, a Connecticut workers' comp compensation first report of injury form would satisfy that OSHA 101 requirement. Family Medical Leave Act, under certain circumstances, federal law requires employers of 50 or more employees to grant up to 12 weeks of leave in a 12-month period to eligible employees. Under similar circumstances, state law requires employers of 75 or more employees to grant up to 16 weeks of leave in a 24-month period to eligible employees.
I had a question on, I'm sorry, Al. Question regarding the type of injuries that need to be required to be reported. Are all injuries required to be reported, or is there a minimum criteria for reporting?
I think that's a Lynn question.
Talking about workers' comp reporting, filing a report with your carrier, that anything that's not just sort of basic first aid should be reported. If you're unsure, you should give your carrier a heads up. If you're talking about the OSHA log, that gets a little more complicated, and the best thing to do when you have some sort of injury is the instructions that come, the detailed instructions that come with the log, and that'll guide you through that.
Great. Thanks, Lynn.
Connecticut paid sick leave. Okay, so Connecticut Public Act 1152, non-exempt employees who work in certain designated service occupations earn 1 hour of paid sick leave time for every 40 hours worked, up to the maximum of 40 hours per calendar year. Their employees entitled to the use of accrued paid sick leave after completing 680 hours of employment measured from January 1st, 2012 for current workers, the date of hire for the employees hired after 1/1 of 2012. the 680-hour requirement is a one-time requirement. An employee is not entitled to the use of accrued paid sick leave if the employee did not work an average of 10 or more hours a week in the most recent calendar year. That's a lot of stuff. Again, very often you're presented with new laws, and they're not sometimes easily understandable. And certainly I know that many folks have taken advantage of this, and we've talked about it, but certainly Lynn Atkinson or Mark Soicher, I call out to them fairly often with questions that I have. It's a great resource to have as a member. But this is kind of one of those things that I would say, okay, what did they just say? And I would want to get some clarification on it. Again, always getting out in front of things so that you are educated and aware. That's one of the things that keeps you in compliance, and then you're going to have less issues down the road. And it's very often not enough to say I didn't understand it, not that you folks would, but it's something that sometimes a regulatory body or an auditor from a government agency is not going to really care about.
Right, and this is one thing that CBIA, if we're guilty of anything, it's saturating our members with what they may say is too much information sometimes. But we've been sending a lot of information out on this over the past year, and there's some good information on the CBIA.com HR website on Connecticut paid sick leave too. So if anybody has further questions, feel free to go there.
Yeah, and just a quick example of who and when is going to audit. I mean, there really is no advance notice in most cases. If it's an agency that regularly comes out and audits, like we mentioned before, ICE, immigration, they will come out at will and do audits as they please. I'm a licensed private detective in the state of Connecticut, as an example, and I'm always subject to audit. I've been licensed since 1993, and no one ever visited me until the beginning of this year. Why they chose to come out at the beginning of this year, I can only guess, because in 2010 they revised the statute, and there was a notification requirement that when I hire somebody that I have to fingerprint them and submit a card to the state the day of hire and a record to the state. When I terminate somebody, I have to send a notice to the state immediately that the person's been terminated. So the failure to register, I think, is a one-shot deal of $75 per event. But the failure to notify the state of a termination is $75 per day for every day that I fail to send that letter off to the state. So all I can think of is, they all of a sudden show up here, after being licensed for so long. I know they were visiting other investigators. It may generate some revenue. It's an easy thing for them to do. How many employees, who's here? We don't have those records that you terminated the person. $75 a day for each day you didn't send the letter in. So that's germane to my industry, but there are many industries out there that have, similar, if there's a licensing requirement, you have to be very careful. The only thing they did was send out one letter when the law was changed, and that was it. That was in 2010. If you read it, great. If you took notice of it, terrific. If you didn't, you could be in trouble.
Right. Now, before we move on, I've got a couple questions. I think this next one, actually the next couple probably for Lynn. Our company has an employee who's given 8 weeks of maternity leave. Do we have to pay everyone else maternity leave, or can we allow this to some and not others? Is there a difference if the employees are at different levels or positions?
No. Generally, the general matter with policies is you're treating everybody the same. That's good. If you're covered by Family Medical Leave Act, that's going to cover maternity, pregnancy leave. It could be eligible for up to 12 weeks, or if you're covered by the state, it could be up to 16 weeks. If you're not covered by Family Medical Leave under 50 employees, then Connecticut has its own disability statute that covers any employer with 3 or more employees, and that is generally ballpark 6 to 8 weeks of unpaid maternity leave, depending on what the doctor is saying, and job reinstatement when she's ready to come back to work.
Great. In terms of the types of companies Are there types of companies that are waived for sick pay? Is the sick leave required for manufacturing companies?
The Connecticut paid sick leave exempts manufacturers.
It exempts manufacturers?
Yeah, manufacturers. Just about everybody else is covered.
Okay, great. Thanks. Okay.
Okay, so one of the things that is important in terms of securing your workplace and making it a safe environment for people to work, other than the safety stuff that we'll cover too. It's best practice and basic security measures to be implemented and maintained by all employers to ensure the safety of the workplace and protection of the company assets. Following elements should be included in an assessment. So you kind of want to take a look at where you're at with these things. So facility access control both during and after business hours. Who has access? When can they come in? Is there free open access? Who has keys to the facility? Doors, locks, keys, card access systems. Use a card access system. It's an easier way to maintain records and be able to control it. But if you're still, using locks and keys, that's fine. But making sure that you have control over those. So people have left that have had keys, for a period of time. It's always a good idea to change the locks periodically. Not that those people will come back and do anything, but the key is out there potentially, and it may fall into the wrong hands. It may not, someone else may obtain that key. Perimeter barriers, you got to kind of look at that. If you have a property where it's fenced in or walled in some way, what's the condition of those? Is it doing the job that you intended it to do? The use of CCTV monitoring. And the reason that some of these things are important really is if you establish some form of security, and you're trusting that that's a form of security, very often the employees are trusting it as well. And if you don't maintain it, you could be giving a presentation that security is lax, and therefore you're exposing them to potential harm. The workplace, should offer some form of general security, and again, sometimes people don't get that concerned over this stuff, but it really can come back to bite you. So, for example, let's say you have a gated property, but the gate is in disrepair. It could be later said that, it wasn't reasonable for you not to fix that gate. And therefore, as a result, you wind up having an issue where someone gained access to the property and someone was injured on the property as a result of it. Someone was attacked. Adequate lighting both inside and outside the facility. That's important. Again, always maintaining that lighting is key. Once you put things in place, you got to maintain them. Otherwise, they become, useless in some cases, and also it can become a problem for you in a liability situation, premise liability. Visitor access policy and procedure. It's important to control who comes into your facility, where they're going in the facility. And again, many companies, of course, have a policy in place. One of the first things I do when there's a visitor access policy and a visitor log, if I'm doing an assessment, I ask to see the log, and I look down the log and see how many people have never been signed out, and I say, where are these people in the building now? It could be days later that I'm looking at that log, but that's important. If you have an emergency situation, the fire department personnel respond to your site, they're going to ask you who's in the building. Where are they? Well, that log can tell them something, but if you're not maintaining it when people leave and signing them out, the fire department personnel could be going to look for somebody who's left the building. Facility opening and closing policies and procedures, again, very important. What are your policies? Who has the right to enter the building? When people enter the building? Again, depending on the type of business it is, if it's a smaller operation, I generally recommend that you never allow one person to go in and work by themselves alone, either before or after hours, or to open up a facility. Again, for safety purpose, if somebody actually took ill and they were there by themselves, they might not be able to seek help, and that could be kind of a disaster. Emergency evacuation or shelter-in-place procedures. This is something that has come up on the radar a lot more in recent years, but it's not something that really was new. I'm sure most of us remember and probably have in place. Some fire drill capability or an evacuation policy, or what if the state ordered you to stay inside, not to leave? If there was an order of a shelter in place, how would you handle those situations? How would you deal with those situations? Can you sustain that? If so, for how long? So these are some things that you need to think about and kind of be prepared for if you're not already prepared. Even if you are, it's always good to go back and relook at them. I did an evaluation of a children's preschool in Manhattan 2 or 3 years ago, and they had a great policy in place. Everything was up to. They had a go bag if they had to leave. They had a secondary site where they could bring the children to. Everything was in place. We opened up the go bag, and the things that were in there that were to help facilitate them, like lists of who to contact, daily. And so none of that stuff was up to date. Flashlights were in there. The batteries were dead. So if you're going to put those things in place, which I think is a good idea to have, is to maintain them. Very important to maintain them. Periodically checking them.
Right. A couple of questions here. I think this first one, if it paid sick leave.
That would be 50 or more employees within Connecticut.
Within Connecticut, okay. The next couple have to do with, I believe, company policy. A few exempt employees seem to think they should be able to take any time off, even after using all paid time off, and still be paid for it. How do we address this, that we expect them to work 8 hours a day, and if they use their PTO, then they're not paid? This might be an offline call to Lynn or Mark, but...
Yeah, it's a little detailed, Tom, but basically, like I said before, if they do work part of the day, they've got to be paid for the full day. Many member companies will have a policy in place that says, our general hours of work are 8 to 5, 40 hours a week, or whatever. The officer said that the exempt employee doesn't necessarily have 6 hours, they just have to get the job done. That said, if somebody's taking advantage, and you think you have exempt employees taking advantage, I've actually heard the Labor Department tell folks that you can always make them hourly, which means they would then be back to being paid only for the hours of work.
Right. Great. This next one, I believe, is a company policy-related question. If an employee loses or breaks a key for our business, can we hold them liable to pay for the replacement locks or keys?
Basically, you can have a policy that says you would expect the employee to repay that. You can ask them to repay it, but as a practical matter, you can't really deduct it from their pay without Labor Department permission beforehand. So it's a little difficult to enforce that type of policy.
Great. Okay, thank you.
Okay, this is one of the favorite things here. Posters. I have a wall, I think now, the whole wall in the break room is pretty much covered with posters. Federal state law requires a number of notices that must be posted in a conspicuous place where employers may readily see it. They're related to the following topics: electronic surveillance, workers' compensation, job safety and health protection, Polygraph Protection Act, sexual harassment, discrimination, wage and hour. And if you use E-Verify, for example, to verify the I-9, you have to have E-Verify posters in, again, a noticeable place that's accessible to employees. So it's
I remind people that all of these posters are available through CBIA.com, the online store. They're very inexpensive, and they really are our biggest seller in terms of product. We get a lot of these out to our members on a weekly basis.
Yeah, and it's great too because they're kind of consolidated on a big poster. You have a bunch of pieces of paper hanging on the wall. It's like one thing that you like our workers' comp, and when it changes annually, we just take and tack over the current notice on that section of the poster. So it's and again, you can be cited for it. Like the first thing that happened when the state came in for my license. First thing they did was to look on the wall to see if my license was hanging up. That's another violation if I don't publicly display it. Termination notices. Okay, although not required, a termination letter can communicate to an employee his or her rights under group health care plans. That is required. Group health, Tom mentioned before about COBRA. Pensions and profit sharing plans and severance of paid time off payments. Also reminds an employee of his or her non-compete obligations and obligations not to reveal confidential information or trade secrets acquired during employment. and an employer should also remember to provide a certificate of creditable coverage. Along a labor separation packet, a final paycheck must be within time frame required for a particular type of separation. So again, it's a good idea to give people reminder notices, the things that they may have signed off on when they first, came to the company, that you want to make sure that they remember when they leave, particularly the COBRA notice. That's important and that's required by law.
I had a question, and that had to do with posters. We have a satellite office that we go to twice a week. Do these posters need to be displayed there also?
I understand that we've got employees in the main facility and they're going off-site once or twice a week. If in the main facility there's a place where most employees would like to see the posters, then I would say no, you wouldn't use them in the satellite office as well.
Great. Excellent.
Okay, so separation packet is formally called in the state of Connecticut pink slip. Connecticut Unemployment Compensation Regulations, Section 31.2.9 requires employers to fill out a UC62/UC61 separation packet for all employees when their employment is terminated, either voluntarily or involuntarily. Failure to give this form to the employee can result in charges of retroactive benefits. So again, if they're granted unemployment compensation, you can get this retroactively if you don't give them this notice when they're actually terminated. And again, it bears repeating, but that second notification is important regarding COBRA. And as an example, this was a case last year in the District Court of New Jersey. A former employee of a New Jersey-based company was awarded damages for an employer's failure to provide a COBRA notice upon termination. So somebody took this company to court, the federal court. The employer was assessed $10 per day from the date of separation until the former employee received a COBRA notice for a total amount of only $2,930, not to mention, as I mentioned here, the fees, your legal fees, to actually defend yourself in this case. So just a simple notification would have avoided this plus those costs.
Right, and keep in mind, it's not on the insurance company or the TPA to provide this. It's on the employer. So I get calls on a regular basis from former employees who were terminated, who aren't using our COBRA service, and they want to know how they can buy COBRA. They think COBRA is sort of its own separate health insurance. You need to have that underlying employer health plan in place to offer COBRA, but it does go back to that employer. It's the employer's responsibility to get that employee that COBRA notification. Again, if you have a third party that's doing it and the employer is contracted with that third party, it becomes the third party operating as a surrogate for the employer. But it does come down to the employer's responsibility.
Okay. So reference procedures. We're talking about like a termination here. Connecticut General Statute 31.128F provides that no individually identifiable information contained in the personnel file or medical records of any employee shall be disclosed by an employer to any person or entity not employed by or affiliated with the employer without the written authorization of such employee, except where the information is limited to verification of dates of employment, any employee's title or position, wage or salary. The statute also includes a limited number of exceptions to the above, such as court orders, law enforcement requests, compliance, federal, state, local laws and regulations, medical emergencies, and dissemination related to collective bargaining agreements. So basically, when we do background screening, as you mentioned, when we call a former employer, we're asking for whatever they'll give us. Primarily, and our recommendation always to our clients who is to limit it to that last sentence here, the dates of employment, position, and if you want to give them wage or salary. It's always with a disclosure and consent. That's a recommendation. You just don't arbitrarily answer the question, get some sort of permission from the former employee. I can't really tell you how many times that an employer discloses stuff to us that they shouldn't have disclosed to us, including medical information. It could be something as simple as the person went out on medical leave. Well, we're going to protect our clients and not pass that information on to them because that's not something that really that they would need to be in possession of. But in terms of that kind of information, sometimes employers really give that up. I don't understand why, but we see it, and they give details in some cases. So it's kind of a very sensitive situation, and one to be cautious about. And again, I would always recommend that as a policy within your company, every employee, managers, supervisors should also, be aware that only one source should be ever contacted in terms of providing this kind of information to, to a prospective employer. And that would be HR or a function such as HR that comes under that umbrella. So you just can't arbitrarily have people, and again, this is where we get a lot of this stuff from. We'll call supervisors to get a qualitative reference, and they'll volunteer additional information. Again, that has nothing, one guy volunteered, he was great until he wound up with that drug problem that he had. And then he went on to tell us about the drug problem. So you should really just make it clear that one source in the company deals with those kinds of requests.
Mm-hmm. I would remind our attendees to get us to questions. We've got a couple more slides here. We should be wrapping up right around 11. And I'd also encourage you to call CBIA HR Services. Mark and Lynn are available throughout the week to answer your questions.
Okay. So, so we've talked about a lot of things here in terms of information that you have to be aware of, things that you have to make sure that you're maintaining. And one of the ways, obviously, to do that is a self-audit, and being aware, knowing what you need to know, which is what this presentation was about, to educate you with regard to things you may not be aware of, that you have to maintain and have in place, and procedures you must follow. So that's the awareness piece that, you should be, doing that. Establishing a regular routine of documented self-audits to ensure that all previously mentioned statutory obligations and regulations being maintained and kept up to date. It's one option for staying compliant. Develop and maintain a methodology to be aware of new laws, regulations, or changes in existing ones, and that's a little more difficult, but that's something that, again, you can look to CBIA for. They're great about notifying of upcoming changes in laws and regulations, making you aware of those things, so pay attention to those bulletins that CBIA sends out. It's a great source. And our experience in-house audit programs, whatever kind they may be, if they're addressing things like this, they fall victim to resources and time, as I'm sure you're all aware of. You set up some practice that on a monthly basis you're going to go through the personnel files and make sure they're up to date, or you're going to check on your OSHA logs, whatever it may be. What happens is something else comes up. All of us seem to have multiple jobs that we handle and not one primary focus. So when those things happen, and again, you have an independent eye. You're looking at your own things that you're kind of maintaining, and I found this myself. Sometimes I proofread a document that I wrote, and I'm not going to see mistakes. I always have someone else proofread it because I'm not going to catch something because I already made the mistake. And chances are, unless it's some obvious glaring thing, but it's those kinds of things that we kind of get into a routine, and we have all good intentions, but they really, don't happen, and there's not, an effective way. But so I'm just kind of stressing the importance of doing some form of audit, and as a result, one of the things that we, Tom and I really talked about early on before doing the presentation was the concept of creating this as an option for you, having a resource to come to help you with these kinds of audits. So we've established this on-site audit program to ensure that you're up to date. Audit orientation checklist, discussion and kind of review of employee handbook, what it should contain, job postings, weekly wage payment exemptions, summary benefit plan descriptions, those, a little bit more detail, but those, there are components in this audit that we put together. And if you need any information on those, you can contact Tom, Lynn, or myself.
Great. Well, we don't have any more questions here, so I would like to, again, encourage you, if you want to learn about the HR audit process, to get in touch with Al, Lynn, or me. Also, feel free to call us anytime. HR-related issues, call Lynn. If you have COBRA issues, feel free to call me. This concludes the formal part of our webinar. We will be making the presentation available in the next day. You'll be able to either find it on CBIA.com or you'll be sent an email with a link to that webinar. So once again, wanted to thank everybody for attending, and feel free to contact us at any point for questions on the HR service function that CBI provides or this new audit function. And I will, again, endorse Al Sparacco, Baker Street Associates, has been really our go-to guy in terms of background checks, and this is sort of an expanded role he's going to be taking on for us, and I'd encourage you to contact him and find out more about it. Thank you.
Thank you.